I have asked Jonathan Diaz to come talk with us about voting rights. I know voting rights is one of those topics that a lot of you are covering on an ongoing basis. So I've asked Jonathan to come do two things. One, kind of put it in, develop the big picture context. So a lot of you are covering what's going on in your states. I've asked him to kind of talk about what's the lay of the land, what are the number of voting rights legislative actions going on, and what kinds of restrictions are they? What have courts said about those kind of things in the past? So I'm asking him to kind of give the big picture national overview that you can put your states in context. And also, he's an expert who's in the thick of this. And so I'm guessing that a lot of you will have state-specific questions that he might be able to answer in the Q&A session. So Jonathan works for the Campaign Legal Center as legal counsel for voting rights. He litigates voting rights cases in federal courts and challenges state laws and policies that deny, abridge, or otherwise burden the right to vote. The Campaign Legal Center, if that's not an organization you're familiar with, is a very good organization to know. I've dealt with them a lot in the past on campaign finance issues, and they have some of the best experts that you can go to find about the legal status of challenges on campaign finance issues. And then they also have a voting rights division, which is what Jonathan is from. So Jonathan, I will turn it over to you. We have him until 11:50, so he'll present and we'll have plenty of time for Q&A. So Jonathan, welcome.
Great, thank you, Chris. It's great to be here with all of you. I recognize a lot of your names from your work. But really happy to be here to talk to you all today about the flood of election legislation that is moving through many of the state houses that you all cover. So my plan for this first half is to talk sort of in general terms about the legal background of election law, policy, administration, with a particular focus on how state level election laws and policies interact with the federal system and federal courts, and then get a little bit more specific into what we are seeing right now in 2021 in state legislatures in terms of legislation affecting the right to vote, and put that both in a historical context as well as just a national present day context. So I'm going to start with the US Constitution. The Elections Clause of the Constitution gives state legislatures the primary responsibility to set the times, places, and manners of holding elections for federal office. But it also explicitly grants Congress the authority to, at any time by law, make or alter such regulations. So in the Constitution, in this explicit grant of lawmaking authority when it comes to elections, the system is designed to have states do a lot of the heavy lifting when it comes to setting rules about eligibility and the process of voting, but those rules are subject to limitations and guidelines provided by the Constitution and federal voting laws. So they have to comply with a number of amendments. Many people, I think, don't realize that the Constitution does not, anywhere in its text, affirmatively state anything about the right to vote. That is not an explicitly granted right in the Constitution. It is something that has been interpreted by the courts and has been sort of read into the Constitution. But there are more amendments to the United States Constitution having to do with the electoral process than any other subject. So that is everything from the First Amendment, which, as I'm sure you all know, protects freedom of speech, freedom of the press, et cetera. The courts have interpreted voting as politically expressive conduct protected by the First Amendment. The 14th Amendment's due process and equal protection provisions apply to voting. The 15th Amendment outlaws race discrimination in voting. The 17th Amendment provides for the direct election of senators by the people. Prior to that, they were appointed by state legislatures in many cases. The 19th Amendment prohibits discrimination on the basis of sex in voting. The 24th Amendment outlaws poll taxes, and the 26th Amendment prohibits age discrimination in voting for Americans over the age of 18. So all of those constitutional provisions provide, the outer boundaries of what states are permitted to do when it comes to administering their elections. They impose limitations. Some of those are pretty self-evident. You can't pass a law that says, only men can vote, or only white people can vote. That's what the 15th and 19th Amendments were intended to address. But there are also a number of federal election statutes that either set minimum standards that the states have to comply with, outlaw certain voting laws and policies that the federal government has determined to be discriminatory or otherwise unlawful, or require uniformity to some degree or another across the states. So the most famous of those is the Voting Rights Act of 1965, passed at the peak of the Civil Rights Movement. But that also includes things like the National Voter Registration Act, which was passed in 1993, sometimes called the Motor Voter Law, which requires states that have voter registration systems to let voters register at the DMV when they get their driver's license. HAVA, or the Help America Vote Act, which was passed in the wake of the 2000 election and the Bush v. Gore decision. And then UOCAVA, which is the Uniformed and Overseas Citizens Absentee Voting Act, which sets uniform rules for Americans living abroad, either serving in the military or in the diplomatic corps, or who just are not in the jurisdiction of the United States during an election. Some non-voting specific federal laws also govern the conduct of elections. Things like the Americans with Disabilities Act requires places like polling places to be accessible to folks with disabilities. And the Civil Rights Act of 1871, also called the KKK Act, has provisions that have to do with outlawing voter intimidation, and private parties preventing people from casting their votes or having their votes counted. I want to talk in a little bit more detail about the Voting Rights Act in particular, because that is one that most directly touches on a lot of the election legislation that we're seeing proposed today and that we've seen proposed over the years. There are two main pieces of the VRA. The first is Section 2, which outlaws any test or device requirement for registration or voting. So it specifically bans things like literacy tests, which were common in the Jim Crow South, for example. And it also prohibits voting qualifications, prerequisites, standards, processes, procedures that result in the denial or abridgment of the right to vote on the basis of race, color, or membership in a language minority group. To pull a recent example, many of the lawsuits, I think all of the lawsuits that have been filed so far challenging the most recent Georgia election legislation bring claims under Section 2 of the Voting Rights Act. So they allege that this new bill has a racially disparate impact and is connected to historical discrimination in the voting context. Section 2 and the Voting Rights Act include a lot of other provisions, things like allowing language minority access to voters who don't speak English. It prohibits racial gerrymandering, or the drawing of legislative and congressional district lines to dilute minority voters' voting power. It prohibits residency requirements of more than 30 days to register to vote in a state. It outlaws voter fraud and double voting and has a voter intimidation provision. So it's a pretty robust set of protections targeted at many of the types of laws and policies that were used to deny the franchise to particularly voters of color in the 1950s and 60s especially. So those provisions remain in effect. And we can talk a little bit more about what that looks like as far as litigation and challenging these laws in court. But the other major piece of the Voting Rights Act was Section 5 and the pre-clearance regime, which, as some of you might know, was invalidated by the Supreme Court in 2013 in the Shelby County versus Holder decision. So prior to that, a number of states, either in whole or in part, were required to submit any changes to their election laws or policies to the Justice Department or to a federal court in the District of DC for pre-approval before those laws could be implemented. And the reason for that was that those were jurisdictions that had shown a consistent pattern or history of racial discrimination in voting. Many of the formerly covered jurisdictions that were subject to this pre-clearance process were in the Deep South and were part of the old Confederacy. But it also included many political subdivisions, counties, cities, townships in the North or in the West that had significant language minority populations and similarly troubling histories of discrimination in voting. So for those of you who are covering states that were formerly covered by the pre-clearance provision, it's important to contextualize the legislative activity that's taking place today with, the fact that that pre-clearance process is no longer in effect. So a state like Georgia or Texas, both of which were covered by pre-clearance prior to Shelby County, would have had to submit all of these changes that they are proposing in their legislatures to the Justice Department or to a federal judge before they would have been able to pass a law or implement a new policy. So just so you all know, since I know you're all from all over the place, the formerly covered jurisdictions in their entirety are Alaska, Arizona, Texas, Louisiana, Mississippi, Georgia, Alabama, South Carolina, and Virginia. And then states that were partially covered, so they had some counties that were subject to preclearance or townships, depending on how their states are organized, are California, Florida, South Dakota, North Carolina, Michigan, New Hampshire, and New York. And because of certain federal requirements, like the NVRA, for example, with the National Voter Registration Act requires registration laws and policies to be uniform across the state. If it's for a state like Florida, for example, where I'm from, since a couple of counties were subject to preclearance, but voter registration has to be uniform across the state, effectively, any statewide change since it affected those counties would have also been subject to preclearance. So in 2013, the Supreme Court in the Shelby County versus Holder decision held that the formula for determining which states were subject to preclearance was unconstitutional. And so it essentially, the preclearance process and the preclearance provisions of the Voting Rights Act still exist, but no jurisdiction is covered under that formula. And so federal proposals like the John Lewis Voting Rights Authorization Act would reinstate a new preclearance formula. But we can talk more about federal proposals later on. So sure.
Yeah, Jonathan, we have one question, one hand raised right now. If we could just take a few questions as we go through, but we'll mostly keep them at the end. But Stephen Gruber Miller of the Des Moines Register raised his hand. What's your question, Stephen?
Hey, thanks. I just wanted to ask if you had thoughts. I mean, you're talking about the connection of some of these new laws and the result from the Shelby County decision. I wonder how much you feel like we can attribute some of this wave of voting legislation to the repeal or to the striking down of that portion. And I ask this as an Iowan who is not in a covered jurisdiction, but Iowa has followed the trend that we've seen really in a lot of states that were covered and were not covered of voter ID laws and other sort of stricter rules. So I'm wondering how much you think there's a connection to the Shelby County decision when we're seeing changes in states that were and were not covered.
Yeah, so that's a great question. I mean, I think that from my perspective, there is, I think, a pretty direct link between the Shelby County decision and just the volume of voting changes that we are seeing, particularly in the covered jurisdictions. But as I'll talk about a little bit more in a minute, these proposals, these changes that we're seeing are really part of a nationwide trend. And so when additional voting restrictions can gain momentum by being passed in states like Alabama and Texas and Louisiana, then you see them kind of bleeding over into non-covered jurisdictions like Iowa. And so to give some concrete examples, in the immediate aftermath of the Shelby County decision, the Leadership Conference on Civil and Human Rights did a report that showed that between 2012 and 2018, the report was done in 2018, there was a total reduction of more than 1,100 polling places in formerly covered jurisdictions, many of them in areas with high concentrations of Black and Latino voters, predominantly in Georgia, Texas, and Arizona. The NAACP Legal Defense Fund also released a report in 2017 called Democracy Diminished that kind of goes state by state through the covered jurisdictions and shows what laws or policies were immediately passed or implemented, in some cases in the very day after the Shelby County decision was released. So I think that there is a really clear through line between how aggressive state legislators are willing to be when it comes to passing or implementing these voting restrictions in the wake of Shelby in a way that they wouldn't have been in, say, 2010 before the decision was passed or came down rather. And I think I saw more chat questions about that.
Yeah, so we have one question. This would be good to get into right now from Ethan,
Sure.
who is from New Hampshire. Could you give some clarity as to why certain states were partially covered by pre-clearance decisions? I'm reporting from New Hampshire, and I didn't realize that we were part of it.
Yeah, I think I'm not sure about New Hampshire in particular, but I know that in several of the states that were partially covered, it had to do with large populations of language minorities. There's a separate section of the Voting Rights Act that mandates that any jurisdiction that has a certain percentage of non-English language speakers, primary speakers, has to provide voting information in that language. So, for example, in some of the covered counties in South Dakota, I believe it had to do with Native American language minority voters in those jurisdictions. So I'm not sure about New Hampshire in particular. There was also a sort of complicated process of having jurisdictions could be bailed in to preclearance as a remedy for losing a voting rights lawsuit. So the Justice Department often requested that federal courts, subject a jurisdiction that they sued for a Voting Rights Act violation to preclearance going forward. And if the Justice Department ultimately prevailed in that case, then sometimes the courts would require that a jurisdiction be subject to preclearance for a certain amount of time. So with all of that background, I guess a little bit more table setting, and then I'll get into 2021. So just some things for you all to keep in mind as far as federal requirements. The National Voter Registration Act, like I mentioned, requires voter registration laws and policies to be uniform across a state, so that different counties can have different voter registration requirements. It also has pretty detailed process guidelines for how voters can be removed from registration rolls. So when you hear about things like voter purges or attempts by election administrators to conduct list maintenance and clean up their voter registration rolls, they have to do so in a way that complies with the process laid out in the NVRA to make sure that they're not removing too many eligible voters from the rolls erroneously. And then things like UOCAVA and the ADA impose similar process requirements and give specific standards that they have to meet for things like when they have to send absentee ballots to overseas voters, or how to make a polling place accessible under the ADA. Maintenance and purge are not one-to-one interchangeable terms. I think both get thrown around by advocates and election officials in the voting space, depending on whether they want to make voter list activity sound nefarious or benign. The way that I would characterize it is that a voter purge is anytime that an election official or administrator conducts an effort to remove a large number of voters from the rolls outside of their normal process, or using a process that has a high risk of erroneously removing eligible voters from the rolls. And then list maintenance, I would describe as a more routine process, for example, of removing deceased voters from the rolls based on information from the Social Security Agency or county officials that track that sort of data. And so you'll hear proponents of more aggressive list maintenance policies describe any policy that removes voters from the registration rolls as it's just list maintenance. And folks who are more concerned about eligible voters being removed from the rolls will be more likely to characterize a process like that as a purge. And so it really is just kind of, they're both, you know, descriptive terms used by advocates in one sense or another. But I think from my perspective, whether a process is routine or sort of ad hoc, if it is conducted in a way that uses, you know, stale data, for example, from a driver's license agency or a healthcare agency that, you know, might not have, that might present a higher risk of erroneous removal from the rolls, I would characterize that as a purge. But not all list maintenance activity. You know, everybody wants accurate voter rolls. Are there any legitimate reasons to remove from the voting rolls people who haven't voted in a long time? That is a great question. I don't believe that inactivity should be a basis for removal from the voter rolls. There was a fairly recent Supreme Court case, a Philip Randolph Institute versus Husted, in which the Supreme Court held that the NVRA does not prohibit removal from the voter rolls on the basis of inactivity, provided that election officials make an effort to contact voters to determine whether they have moved or died or become ineligible for some reason. You know, I think that there are a lot of implementation problems with systems like that. Often election officials will send postcards to a voter's registration residence, and if the voter doesn't respond and hasn't voted in 2 general election cycles, then they can be removed or placed on an active status. I don't know about you, I don't respond to every postcard that I receive in the mail from, you know, that I didn't request. So, you know, there have been studies conducted by folks like Demos that show that this non-contact process is not a super accurate way to determine whether a voter has moved or is no longer ineligible. And, you know, we don't have compulsory voting in the United States. Voters may not vote for a whole number of reasons. Anything from, you know, being dissatisfied with the candidates that they're presented to, you know, not having sufficient opportunities to vote because they work multiple jobs, and absentee and early voting may be limited in their jurisdiction. So it's a fraught process. So I don't think inactivity is a particularly good metric for elected administrators to use when removing people from the rolls. But I do want to talk about the current ongoing, you know, election legislation that's happening all across the country. And I know that many of you who are covering state houses, I think that's all of you, are probably much more familiar than I am with what's going on in your particular states. But to give kind of the big picture overview, just yesterday, actually, the Brennan Center for Justice at NYU updated their count of pending election legislation. It is up to 361 bills that the Brennan Center has characterized as restrictive or anti-voter in some way that have been introduced in 47 states, which is, as you know, almost all of them. That's an overwhelmingly high number. And to go back to the question that Stephen asked earlier, I don't think we would be seeing this kind of volume of election legislation being even proposed, but for the Shelby County decision, making it easier for states to pass potentially discriminatory or restrictive laws without any federal oversight or pre-approval. You know, many of these bills, as you guys know, will never actually become law, but you know, some of them already have. I think at least 5 bills have passed in Arkansas, Georgia, Iowa, and Utah, and at least 29 have already passed through at least one chamber of their state legislatures in other states. And you know, now that we are really in the thick of the legislative session in many states, you know, things are moving through committees and starting to be scheduled for floor votes. So most of the restrictions that we are seeing these days have focus on the absentee ballot process, which, you know, for a long time, I don't think was the subject of any kind of particular controversy because most voters liked absentee voting kind of across the political spectrum. But during the 2020 election, partisan lines were drawn in the sand about absentee and mail voting, and former President Trump and his campaign and many of his allies made it a political strategy to really cast doubt on the legitimacy and the security of absentee and mail voting. And so now we are seeing sort of a backlash to the overwhelming use of vote by mail and absentee voting in states across the country because of the pandemic, that data and polling have shown were overwhelmingly utilized by Democratic-leaning voters in 2020. And so now many Republican-controlled legislatures are seeking to restrict access to absentee voting, where in many of those states, absentee voting bills, including no excuse absentee, were originally introduced and passed by those same Republican legislators. In states like Arizona and Florida, Republican voters and Republican campaigns tended to really emphasize voting by mail because older voters really like vote by mail, and older voters tend to skew more Republican. And so this kind of partisan realignment around absentee and mail voting is something new. And it's really motivated and connected to the same kinds of conspiracy theories and misinformation and fraud and false narratives that we saw during the 2020 campaign and in the wake of the 2020 election results about voter fraud and insecure elections, which were roundly dismissed by the 60+ courts that heard the post-election lawsuits by President Trump's own Department of Homeland Security and Department of Justice. But this belief that the 2020 elections were inherently fraud or fraudulent, I should have said flawed, and somehow illegitimate, has really permeated the Republican base and Republican legislators who have made this sort of the centerpiece of their legislative strategy during this year. The other major focus of a lot of the election legislation that we've seen across the country has been a real emphasis on removing authority for election administration and rulemaking from election officials, both at the county and the statewide level, and placing that power in the hands of legislators. So election officials and county boards of election or election supervisors, many of them are elected directly by their constituents. Many county election boards are either non or bipartisan. But all election officials, in all of the states are charged with administering elections in a nonpartisan manner. And the state legislatures that are trying to exert more control over the election process are really doing so with often nakedly transparent partisan aims. In a state like Arizona, for example, the Arizona Senate is trying to conduct its own audit of Maricopa County's 2020 election, which was already audited, and doing so in a way that kind of cuts out the Republican majority county commission and the Secretary of State of Arizona. Similarly, the recent Georgia law that was passed gives the legislature greater authority to, remove or otherwise, interfere with county election administration without really clear standards for, what is misadministration, what justifies the state's sort of intercession in the county election administration. And so the potential for abuse for partisan aim is really, I think, a concern with what was passed in Georgia. And the reason that we're seeing this kind of concentration of electoral administrative power in the hands of state legislatures, I think has a lot to do with partisan gerrymandering. These legislators in most states draw their own legislative lines, and so are able to draw legislative districts in a way that protects incumbents and protects their own partisan majorities. The Supreme Court heard a partisan gerrymandering case that, full disclosure, CLC litigated, called Rucho versus Common Cause, that was decided in 2019. And the court, in a narrow 5-4 decision, much like the Shelby County decision, held that federal courts have no role in adjudicating partisan gerrymandering claims. And so it is really kind of up to state legislatures. They are permitted to draw lines in a way that will benefit the majority party. And so they are more insulated from electoral consequences than, say, a Secretary of State who is elected on a statewide basis. So they can, make these election law changes without having to worry about political blowback when they enact laws that are unpopular, sometimes even among members of their own party. And so I know that I'm getting more questions.
Yeah, we got some more questions. I mean, if you're kind of done with your, if you're done with your kind of your overview points in the next couple of minutes, then we'll have a block of time for Q&A if you're able to.
Yeah, I just have one or two more big picture points that I want to make. So I think that it's important. I know that all of you are focused on your particular states and your particular state houses, but I think it is really important to contextualize a lot of this legislative activity against the backdrop of what is happening nationally. I'm sure that many of you have seen the New York Times reported last week that this kind of flood of election legislation is really part of a coordinated nationwide effort being undertaken by the RNC and with input and help from groups like the Heritage Foundation and ALEC and other big actors in the conservative legal and political spaces. So state level legislators are not coming up with these things on their own. It's part of a nationwide partisan effort to restrict access to the ballot for partisan gain. And the RNC's work on this is being led by this election integrity committee that is made up largely of party officials and members who were involved with the unsuccessful attempts to overturn the results of the 2020 election, who organized Stop the Steal rallies. And I don't think that you can really separate the conspiratorial nature of the post-November landscape leading up to the January 6th insurrection from this renewed push to restrict access to the ballot, because it's all designed to feed it to fulfill this narrative that the 2020 election was stolen and therefore voting has to be made more difficult to prevent that from happening again. When in fact many of these restrictive laws don't have any factual basis. And are just designed to appease these conspiracy theories or to secure a partisan advantage at the expense of democratic principles. And so, election law and policy and these debates that are being had, I know that it can be easy sometimes to look at this as a left versus right or Republicans versus Democrats narrative because, these laws will have an impact on the outcomes of elections. But I would urge you, when you're talking about how a proposed law or policy might, change things, to really focus on what the impact will be on voters, because they're the ones who are going to feel the brunt of these laws and policies in a much more direct way than, who gets elected or, how campaigns are going to position themselves around what campaign strategy will be. Because, these policies are not just going to affect Democratic voters. It's going to affect voters of all political affiliations, rural voters, older voters, younger voters, voters of color. And it has real, even if it has short-term gain for, say, a particular candidate, I think that once we reduce election policy to what is going to help my team win next time, that has a real lasting long-term damage on the health of our democracy as a whole. And when you have a party that is seeking to win elections by restricting the size of the electorate rather than by trying to appeal to more voters, at the expense of democracy, I think that that's a really dangerous trend and something that needs to be at the forefront of all of these conversations about voting rights and about this election legislation. And so, yeah, so when you're looking at these things, I would just urge you to consider the historical context and the national context and how what's happening in your state is reflective of this broader anti-democratic trend, little d democratic, not the party, the system. And when legislators give justifications for these bills, really probe that and consider whether those justifications are pretextual. I saw a lot of legislators in the last couple of weeks talking about how the bills that they're proposing are, to make things easier for disabled voters. When, the disability rights activists and the disabled voters that I work with are, up in arms about these bills because they haven't been consulted. And, the things that they are really concerned about from an access standpoint are not being addressed by this legislation. So that is, I think, everything that I had prepared to ramble on about. I know that it's a lot,
Yes.
but happy to take questions.
So we have a handful of questions, either hands raised or in chat, and we'll get through Jill, Sam, Stephen Caruso, Stephen Fowler, and Stella, and we'll start with Jill.
Hi, Jonathan. I'm Jill. I'm a producer and reporter for the Texas Standard statewide public radio program in Austin, Texas. We have measures here in the state that propose to expand rights for poll watchers, and I'm wondering if you could go into detail about what poll watchers can and cannot do, and where that line could be crossed by some of these proposals.
Sure. So, exactly what poll watchers can do and the particular regulations around them are, like everything else in election administration, going to vary state to state. But with respect to Texas in particular, I think that the bill that has been proposed and I think was passed by the Senate in Texas really gives poll watchers who are partisan actors selected by the parties really broad latitude to, not just to observe, but potentially to interfere with the process of election administration in ways that are really concerning. Because that particular bill would allow partisan poll watchers to do things like, for example, take photographs of voters who are getting assistance, say language accents assistance, if they think that the voter shouldn't be doing that. And when you have in a place like Texas, a lot of Latino voters who may have Spanish as their primary language, who are using assistance as they are legally entitled to do, that seems like a very easy slippery slope to voter intimidation, and to racial profiling, and to have partisan poll watchers harassing voters, or even after the voting process has concluded, harassing election officials and poll workers who are volunteers or county employees who are counting and processing ballots. We saw a lot of that in the days following the 2020 general election, where poll watchers were observing ballot processing and counting in places like Arizona and Pennsylvania, which they had to do from a certain distance. And that's meant to preserve, number one, like the privacy of people's ballots, but number two, like the safety and integrity of the work that the poll workers are doing. And so eliminating limitations on what poll watchers rather can do, I think opens the door to a lot of potential harassment or intimidation by partisan actors who could abuse that authority to interfere with the electoral process.
Okay, so we got a question in the chat from Sam Metz, who's with the AP in Carson City, Nevada. Can you talk about how to personally weigh arguments about voter ID bills and if possible lay out the different kinds of them?
Sure. So, I mean, voter ID is a pretty popular policy and is pretty common. The issues surrounding voter ID and where some of the opposition to voter ID laws and policies come from is the fact that states often tailor their voter ID laws and policies in a way that benefits the types of voters that are more likely to align with one particular party over another. For example, in some states, you can use a gun license as a voter ID, but not a student ID. And that's because, I guess, of a perception that gun owners are more likely to vote Republican and college students are more likely to vote Democrat. In other states, the requirements for what information has to be present on an ID are very, very strict. so much so that it can be impossible for certain voters to meet those requirements. And so if you're requiring everyone to show an ID to vote, you need to also make sure that an ID is accessible to every voter. And in many states, in many cases, the way that ID requirements are structured makes that impossible. So for example, we litigated a case in 2018 in North Dakota because they had a very strict voter ID law that required a voter's photo ID to show their residential street address on it. But many Native American voters living in Indian country, in particularly in rural parts of North Dakota, didn't have residential street addresses. So their North Dakota driver's license or their tribal ID, just could not meet the requirements of the state law for them to be able to vote. You had multiple state agencies in North Dakota, like the fire response system and the Secretary of State's office, and different agencies in North Dakota were assigning different conflicting street addresses to the same property. So when a voter ID law is structured in a way that, based on the types of ID that are permitted for use in voting, discriminates against certain populations, or makes it impossible for some voters to get the necessary ID, that's when it poses a real problem. And so opponents of voter ID tend to focus on the burdens that a strict voter ID requirement places on certain segments of the population, and the lack of a reasonable impediment exception. So some states that have strict voter ID laws have an alternative option. So if a voter cannot obtain the necessary ID because they don't have a birth certificate or they don't have a street address or whatever, they can sign an affidavit under penalty of perjury saying, I am a registered voter, I live in this state, I am eligible, I can't obtain an ID. Other states have tried to provide free IDs to voters, but I don't think that most advocates would say, we need to get rid of voter ID entirely. We just need to make sure that voter ID doesn't create an insurmountable barrier for some voters, especially poor voters, rural voters, and voters of color who often disproportionately lack the kinds of IDs that are mandated by the state.
Okay, so next question, Stephen Caruso.
Hi, I'm Stephen with the Pennsylvania Capital Star. Just sort of a quick question. There are these viral tweets that go around in conservative circles, and also I hear it when talking to lawmakers backing voter ID, that oh, well, you need X, they'll rattle off all these things that say you need ID for, but you don't have voter ID. Have you ever how much truth is there to these arguments? How many of these things that people are claiming, in theory, yeah, maybe it says somewhere that you might need an ID for this, but I'm just, has anyone have you fact checked that before? I'm just curious.
Yeah, that's an interesting question. I think that a lot of the comparisons that are made were you need photo ID for XYZ thing and not for voting are untrue along two axes. Number one, I think oftentimes the people making those claims know that photo ID is not actually required for the thing they say it's required for. Or they are in a jurisdiction where photo ID is required for voting. But I think the more important rejoinder to arguments like that is that many of the things that people claim voter or photo ID is required for are not things that you have a constitutional right to do. You have a constitutionally protected right to vote, and so you don't have a constitutionally protected right to, I don't know, whatever the thing is. It's often not the case. And so, because the right to vote is paramount, the Supreme Court has said on multiple occasions that the right to vote is the most fundamental of rights because it is preservative of all of our other rights. Something like a photo ID requirement for voting needs to be subject to harsher scrutiny than a photo ID requirement for something else that is less important because of how fundamental voting is to our system of government. And so, it's not that photo ID is, presumptively always bad under all circumstances and shouldn't, and all that. It's that, we need to look very carefully at photo ID requirements to make sure that they are not creating barriers to voting, so much so that it makes it impossible or difficult for people to vote. which I think in many cases I would argue that it does.
Okay. So I have a question from Stella, who's with the Tennessean in Nashville. Tennessee has more obstacles for voting rights restoration than other states. It requires people to be up to date on child support, for example, to restore their voting rights. Bills expanding that are likely to die this year since the GOP has been resistant to the idea. Could you speak to the impact of this on disenfranchising voters?
Yes, Tennessee is, I think some people are surprised to learn, I think maybe the most restrictive state when it comes to voting. Tennessee is one of the handful of remaining states where you still need a statutorily prescribed excuse to vote absentee. They have the most convoluted and confusing felony disenfranchisement system in the country, where whether and when you get your rights restored after a felony conviction depends on a whole number of factors, including the year in which you were convicted. And so our Restore Your Vote program, which focuses on felony disenfranchisement issues at CLC, has done a lot of Tennessee specific work. And so, you know, something like Tennessee's bananas requirement that a voter be current on their child support payments in order to have their voting rights restored after a felony conviction, in addition to paying all the other legal financial obligations that are associated with the conviction, is just an often insurmountable barrier for voters or for Tennesseans trying to regain their rights to vote, and something that has nothing to do with voting. You know, we at CLC, we were part of the coalition of organizations that challenged the Florida law passed after Amendment 4 that imposed strict financial obligations, or didn't impose them, but required voters with felony convictions in Florida to pay all of their felony-related financial obligations, many of which were impossible to determine before having their voting rights restored. And you know, we had a number of expert witnesses, academics who looked at the data, looked at the number of voters affected by this and the types of funds that were required. And you know, it numbers in the hundreds of thousands in Florida alone of people who otherwise would be able to restore their voting rights, but can't afford to. And saying the phrase, you know, somebody can't afford to be able to vote in 2021 is deeply upsetting. But it's not a problem that is unique to Florida. Tennessee is another, you know, particularly egregious example, but many states have similar such requirements of paying financial costs to have voting rights restored for people with felony convictions. And this is actually a great time to highlight something that I didn't mention, which is for those of you who have criminal justice reform or criminal law proposals on your beats as well, I think it's always important to think about how criminal law intersects with the election system. Anytime, in most states, anytime something is proposed that would create a new felony or would bump something up from a misdemeanor to a felony, oftentimes that will carry the collateral consequence of disenfranchising someone for the term of their incarceration or the term of their probation and parole, or in a few states indefinitely. And so when you're talking about criminalization, especially in states like Florida that is considering a pretty strict anti-protesting bill that would impose a lot of criminal penalties for certain types of protests, you know, think about the ways that, you know, it's the same government, it's the same legislature that is deciding what to criminalize and also deciding whether people who it has deemed felons can regain their rights to vote and when. And so all of these issues are super interconnected.
Okay, well, it's 12:50. I have one question. Let's see if we can get to this pretty quickly. It's from Stephen Fowler at Georgia Public Broadcasting. What types of arguments have been persuasive in convincing courts of a Section 2 challenge? In Georgia, we have a long history of suppressive laws that more blatantly target Black voters than our new 98-page law being challenged right now.
Yeah, Section 2 cases are, I think, very difficult for voting rights plaintiffs to bring because they tend to be very resource intensive. The Section 2 test, as articulated by a number of circuit courts and currently being considered by the Supreme Court in a case out of Arizona, requires challengers to show not only that a law has a racially discriminatory impact, so that that can involve statistical data, testimony from voters and experts, showing that minority voters will be more harshly affected, will have a greater burden on their ability to vote because of a law. You also have to link that that law to a number of factors. They're often called the Senate factors or the Jingles factors that are used to show a history of racial discrimination in voting and in society generally in that jurisdiction. So that can be anything from statements from legislators during the debates over the bill to whether the legislators knew about the disparate impact and proceeded to pass the bill anyway, to things like whether housing discrimination or economic discrimination or disparities adversely contribute to a minority group's ability to comply with a certain voting requirement. So one of the major Section 2 cases in recent history came out of Texas on Texas's voter ID law. And so some of the evidence that was considered by the courts in that case was the fact that Black and Latino voters in Texas were much less likely to have a driver's license or to be able to afford the fees and the costs associated with obtaining the necessary ID because of historical and social discriminatory factors. So it's a really resource-intensive litigation process. It requires a lot of expert witnesses, historical experts, economic experts, demographic experts, and the evidentiary records in these cases are often massive, and they can take years to resolve. So it is, it's a remedial tool. It's not a prophylactic measure. You can't bring a Section 2 case until a discriminatory law has been enacted. And so that's the big contrast between that process and the pre-clearance process that happens beforehand. As far as what specific evidence would have to be brought in a Section 2 case, it really is so context specific. It depends on what group is challenging it, who is allegedly being discriminated against, and in what way. So something like a reduction. I know that this wasn't in the final Georgia bill, but say a law that eliminated Sunday early voting, you would have had, statistical data showing that Black voters were more likely to vote on Sundays during the early voting period, and sociological or historical experts to talk about souls to the polls and Black church traditions and things like that. So it is really, really context specific and very, very resource intensive, which is why the Justice Department is often the primary player in Section 2 cases, although that hasn't been the case recently.